Hello, everyone, and welcome to Uncivil Law. For today's case, we have a story about people who object to class action settlements, perhaps not because of any just cause, but because they think that perhaps they can extract a little bit more money for themselves. Perhaps this is the American way, but it has become a bit of a bother to the courts, and that brings us to today's case. This is the case of Nick Peterson versus Target Corporation, but really involves the appeal of another guy, Theodore Frank. So Theodore Frank is part of the class action. He's not a named party, but he's part of the class. And so he is objecting to the class action settlement, but perhaps for improper reasons, and maybe the court should do something about it. So what happened? Why should we be concerned? Let's get started with this. We address in this case a recurring problem in class action litigation known colloquially as objector blackmail. The scenario is familiar to class action litigators on both offense and defense. A plaintiff class and a defendant submit a proposed settlement for approval by the district court. A few class members object to the settlement, but the court approves it as fair, reasonable, and adequate under the federal rules of civil procedure. Whether or not that's true or not is a whole other set of problems. The objectors then file appeal because they can. They have standing. As it turns out, though, they are willing to abandon their appeals in return for a sizable side payment that do not benefit the plaintiff class, a figure of blackmail by selfish holdouts threatening to disrupt collective action unless they're paid off. Okay, so I have a couple different thoughts about this because this is something I've read about a fair amount. So in any class action involves a lot of people and a lot of money is involved. And so you will have people who will file objections and then go to appeal. And then say, for a price, I'm willing to settle my appeal. And then it becomes just an issue of settling off the labor cost of the appeal. So, if it's only a few people, and it usually is only a few people, it's cheaper to settle than it is to pursue it to appeal. And so there's that. Now, one could view that as proper or view it as improper, because a lot of these class actions, when they settle for very small amounts of money, or sometimes nothing at all, or comparatively nothing. So there might be really good reasons to object. And so you're like, well, what I was offered as part of the settlement was basically a coupon. And, we hope you don't get sad at us next time. I didn't really feel very good about the coupon. I wanted something more. So if they offer you some amount of money and you feel that would make you whole, then you've been made whole. So you really have no reason to complain. So on the one hand, you could view it as a person just raising a stink for blackmail. But on the other hand, you could just view it as a person who's like, my rights weren't satisfied. And then if you make me whole, then I'm whole, so what do I have to complain about? But this has been a problem among the courts of appeals, and they're trying to figure out ways to deal with this. So these renegade people are trying to uphold the entire uphold the entire class action settlement system. That is what happened here, says the court. 3 objectors appealed, which is kind of typical, these kinds of numbers when you're doing this, and the denial of their objections to a class action settlement, and then they dismissed their appeals in exchange for side payments. In other words, because they thought they were satisfied, they dismissed. The last time this case was here, we called these selfish objectors a serious problem. So, yeah, what's wrong with being selfish when you've been harmed? I'm not 100% sure because you want to be made right, but okay, this is a problem. The question before us now is whether on a motion of another class member, so another class member is sad that they didn't have the idea. So one of the other class members is upset that the class member thought of it and now would like a piece of the pie. So whether this other class member, if the district court has the equitable power of the remedy to solve this problem by ordering that the settling objectors to disgorge for the benefit of the class the proceeds of their private settlement. To disgorge is a very, very fancy word for give us the money. Give us the money. The money that you got as part of your settlement, that's ours now. That's disgorgement. Yoink. It's like that you shouldn't have gotten that money. That's our money. Even though we could have complained and we didn't. You did. And we want the money. And so we're going to get the money. And then we call it disgorgement. Ooh. The district court held that it did not have the power to take money from people, finding that the objectors had not intended to or actually committed any illegal act, nor had taken the money out of the common fund, which they didn't. They didn't take the money out of the common fund. It was a side deal. And it wasn't fraud. There wasn't any proof of fraud. They had a legitimate claim, and they settled a legitimate claim. Happens in court every different day. So the district court said, we don't see any problem. But the Court of Appeals says, we see a problem. Okay. Falsely flying the class colors. We do like our flag metaphors over here. These three objectors extracted $130,000 from what economists would call rents. Yeah, if we want to put it another way for economists, rent seeking. So this is rent seeking. Economists are doing rent seeking from the litigation process simply by showing up and objecting to the consummation. That's a strange word, consummation. Normally when something else is being consumed, there's another. Yeah, normally when someone is consummating something, there is another word for that that might also refer to this particular process. What other word is there for consummating that might refer to the sensation that a person might be getting from being disgorged? I'll leave it to your imagination for those of you who can put two and two together. So anyways, they're objecting to the consummation of the settlement to slow things down until they're paid. We hold that settling an objection to assert the class rights in return for this private payment to an objector is inequitable, and that disgorgement, in other words, we're going to take your money, is the most appropriate remedy. So yes, taking your money is cool, is definitely a thing we are going to do. The district court approved the settlement in question. All the three objectors appealed, all dismissed their appeal before they began. The dismissal struck Frank as suspicious and possibly in bad faith. So Frank is one of these people. He's not happy. He sought to reopen the case in the district court by filing a motion for disgorgement, I want their money, of any payments made to the objectors in exchange for dismissing their appeal. We reversed, concluding the district court had jurisdiction to entertain Frank's motion, and that Frank should be allowed to pursue his theory of I want some of that money. On remand, the discovery showed the three objectors had indeed received two side payments, also known as settlements, in exchange for dismissing their appeals, $60,000 each to Nunez and Buckley, and $10,000 to Sweeney, who apparently was not as sharp, totaling $130,000, while the class had received nothing. The district court, however, concluded the record failed to confirm suspicions of blackmail or other wrongdoing, so there was nothing indicating that they were trying to do something wrong, and so they denied discouragement because it's an equitable remedy. Nunez, Buckley, and their counsel asserted they had pursued their objections in good faith and not for the purpose of blackmail. Okay, so we want some of their money from these people who made side settlements, so we have to figure out what are the standards that apply. How do we determine whether or not to do that? What are the standards for this particular equitable remedy? So let's read a little bit further. A motion for disgorgement is addressed to the equitable discretion of the district court, and we review that ruling for abuse of discretion. So apparently, it was abusive not to order this discouragement, which seems like a really strange conclusion, but okay. We base our decision here on a long-established principle of equity. It has been axiomatic that no person shall profit by his own wrong. A fiduciary's self-dealing is treated as a constructive fraud. We have little difficulty applying these principles to private payments made to an objector in exchange for withdrawing the appeal of an objection asserting the interest of the class. That seems like a slightly strange thing, because to say that a fiduciary who treats somebody, then that's a constructive trust. Makes total sense. They're a fiduciary. They have a duty of care to their client or to whoever they have the fiduciary duty to. So if a fiduciary steals and cheats, then if there's money to be gotten back from the fiduciary, we can take it and put it in a constructive trust. Makes total logical sense. But how are we doing that for another class member? A class member doesn't have a fiduciary duty to another class member. The lawyer for the class certainly does, but how are you applying what's true for a fiduciary to a random class member, especially if they're not the named plaintiff of the class? Maybe them. Maybe the named plaintiffs of the class have a fiduciary duty. But random class member? I don't know, man. I'm not sure how that logic quite applies. As in a prior case called Young, three objectors' representative responses to the class in this case were emphasized by the fact they would have been entitled to seek compensation for their services if their appeals succeeded. On the same principle, named plaintiffs each received $5,000 incentive of awards, and Frank was awarded $180,000 in attorney's fees for substantial class benefits he achieved by objecting to the first settlement. This case turns on a simple either-or proposition, whose logic flows directly from the prior case of Young. These objectors made sweeping claims of general defects in the settlement. Either these objections have enough merit to stand a genuine chance of improving the entire class's recovery, or they don't. If they did, the objectors sold off that genuine chance, which was the property of the entire class for their own strictly private advantage. Yeah, but if they were the ones wanting to pursue it, like the original class members could have chosen not to pursue it either. So they're really not doing anything different than the original class. Like the original class members could have chosen to settle. I mean, for them at least, but they chose to pursue it, and these class members want to settle. So how is it any different? I'm not sure. If they did not improve the entire class, the objector's settlement of meritless claims traded only on the strength of the underlying litigation, which is also true of the class representatives, incidentally, and also the property of the entire class, to leverage defendants and class counsel's desire to bring it to a close. Either way, the money the objectors received in excess of their own interests was not paid for anything they owed and thus belonged in equity to the entire class. Ours is an adversary system of judgment. When defendants and class counsel seek to settle a class action, the clash of adversaries on which the system depends is lost. The district judge must act as a fiduciary of the class and assign whether to approve a settlement, which, makes sense for the judge, not so much for a class member, though. We do not expect reasonable and good faith objections to be deterred or chilled by our holding here, really? Particularly in light of the 2018 amendment to the Federal Rule of Civil Procedure addressing the problem of objector side deals. The rules now require that an objection state whether it applies only to the objector, to a specific subset of the class, to the entire class, and also state with specificity the grounds for objection. The rules require the district court to approve specifically for foregoing, dismissing, or abandoning an appeal of denial in exchange for payment or other consideration. Good faith objectors should be able to say specifically why the class or part of it has been deprived of the fair, reasonable, and adequate settlement to which it is entitled. By definition, such objectors expect to be able to improve the class position, whether by compromise or favorable judgment, to which equitable compensation is available. We do not expect any good faith objector will fail to bring his or her objection because she is prohibited from selling out the class in exchange for a private payment, which again, the class representatives seem like they're no better off, which she may choose instead not to sell out the class and still receive a payment if she brings the class a real benefit. And we trust no district court will be misled by the facially expedient of addressing of a class-based objection in individual clothing to avoid scrutiny under our decision here. Thus, that brings us to the case of Nick Pearson and Target Corp, and really by way of Theodore Frank, who is bringing this party together. So one of the people to a class objected to the class and then settled privately for it. And the Court of Appeal says you can't do that, and we're going to take your $130,000 that you got, and we're going to put it to the common fund for the common good. And so, maybe this is the end to these so-called class-based blackmailers. That's a problem, but at least for a moment, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.